she fell down an elevator shaft.
I was going to say an
You're
elevator.
Gonna say so you're going to say that. Get a little closer. Get a little closer.
Elevator, yeah.
Elevator. There we go. Okay. We have in the studio with us Peter Lagarius, who is a specialist with class action suits, or actually that's what we're going to be talking about today. So Mark, you were going to lead in with a question.
Yeah, we had, we talked last segment about how, oftentimes these class action suits are against large companies, and oftentimes it's for maybe an overcharging of a fee, and the payoff to the individual client's usually not that much. But can you give us some examples of class action suits where the payoffs were considerable to the participants?
Well, a good example is a group of Exxon franchisees filed a lawsuit regarding price conduct. They were getting gasoline and there were other charges involved, and that case actually was a class action that was tried in a court of law. It didn't settle, and it was enormous amounts of money because of the volume of transactions going on in a franchisee dealership.
How many franchisees were there?
I don't remember. You're putting me on
the
spot for the number.
But it can't be millions. I mean,
no. There were probably thousands, but I'm not even certain of that. But there were many franchisees, and it was a class, and it went to trial. Wage and hour and misclassification of overtime.
Oh, right, we read about those quite often.
And those can be substantial. There was a class that was certified for discrimination against women in the Walmart system that went all the way to the Supreme Court, and they turned it down for class certification.
Really?
And that was going to involve many women that were employed by Walmart, but ultimately the Supreme Court declined to certify it.
Well, and I'm just thinking this is the perception. Okay, I'm not saying this is my perception, but I think the perception is that class action attorneys are sort of out there like ambulance chasers looking for these kinds of cases, rather than a situation where, like the Exxon case, where you have a plaintiff coming and saying, look, I know this is wrong, and how much would it cost each franchisee to hire his own attorney for basically the same kind of claim, right?
Well, where is the outrage for the corporations spending all the money to defend?
That's a good point.
Right, those could be profits to shareholders.
Yeah.
Well, but the fact is that the defendants in these cases are paying the lawyers all along, and nobody seems to be outraged with those lawyers.
Yeah, but they're not the ones who are starting it, though, right? Someone's bringing them a case where suddenly they now have to hire attorneys.
Well, should individuals in the United States of America be entitled to file lawsuits if they've been aggrieved? And the answer ought to be yes.
Yeah.
And will some lawsuits be filed that aren't meritorious? Yes.
But that happens whether it's a class action or not.
Exactly.
I mean, it's economies of scale.
There's a good word to use with class actions, and in fact, as a matter of legal theory, the courts would be swamped if you have a class of 1 million people that had this credit card transactions, and they were all bringing their individual lawsuits. The courts could not handle it.
Well, that brings me to the most recent case that has been in the news, and this has to do with Honda. And there is a woman who is deciding not to join the class action suit, and basically the suit has to do with mileage. Apparently she bought the car thinking she was going to get 50 or 60 miles to the gallon because it's a hybrid, and apparently it's being determined that she's only getting about 30 miles per gallon.
That's a big difference.
That's a pretty good size difference, and I guess they're trying to prove that Honda's to blame for this. So there's a class action suit going on, and she's deciding that she happens to be coincidentally an attorney, but she's not acting as an attorney. In this case, she's acting as just a plaintiff. And she's deciding that it's better for her, because I guess the dollar amount involved, to go to small claims court, which is now up to $10,000. So I was going to ask Peter on this, at what point does one decide, no, I want to do a small claims court on my own case? Because here was one of the advantages that she thought was the fact that in small claims court, the defense, or neither one actually, gets to have lawyers in the courtroom. So Honda, if they respond to this or don't respond, they're going to need to have some employee who's not an attorney represent them. So, how does one decide, like, what's
Well,
best?
an individual going to an attorney seeking representation has to present their case, and during a discussion with the attorney, it may come up. The individual may think about a class action on their own, or they may ask the attorney about it, or the attorney may find out, well, are there other people that this is happening to help prove the case, and it may come out. Bringing a class action requires an individual to be the named class representative, and sometimes more than one will be named, and that person has special duties because they're not just bringing the case for themselves, but they're bringing it on behalf of a class.
And as a potential claimant, you can opt out. I mean, not everybody has to be part of the lawsuit. Like this lady, she's saying, no, I'm going to opt out and do my own case.
Yeah.
So at least she has the choice.
That is correct. When a class is certified, the court will notify all of the class members, and there's an issue about who pays for that, but it's typically done by a postcard or something like that. And individuals can make a decision, and they can decide, I don't want to be part of this class. Now, there's some other exceptions to this rule. In some instances, you're automatically included unless you opt out. But in most cases, you're not. You need to make this decision.
To actually opt in.
So you get that thing in the mail where you're supposed to take some kind of action. It tells you.
It tells you you have a period of time to opt out.
Yeah.
I mean, I guess that's kind of the best of both worlds, because then at least it's up to the individual person.
Mhm.
They may say, you know what, if I do have a claim here, okay, I'll take it on myself and try to figure out who to sue, which is usually kind of hard to do. But hey, there's a couple of quick lawsuit type things I thought were kind of funny that the audience may be interested in. If you can't sue the system, sue yourself. In 1995, this gentleman sued himself for $5 million. He claimed he had violated his own civil rights and religious beliefs by allowing himself to get drunk and commit crimes, which landed him in some correctional facility, serving a 23-year sentence for grand larceny. And let's see, what could he possibly have gained by suing himself? Since being in prison prevented him from having an income he expected the state to pay. The case was thrown out. Here's another one. Mistaken for a superstar. This is kind of a fun one. How insulting. In 2006, this gentleman sued Michael Jordan and Nike for $832 million. He claimed to suffer defamation, permanent injury, and emotional pain and suffering because people often mistook him for the basketball star. Yeah, that's got to be bad, huh?
That's one way to try to game the system.
Yeah. Now, Peter, how do people get a hold of you if they have a potential class action suit?
We are located in San Rafael, and they can call us at 415-460-0100, extension 111 is my number. We also have a website, Ligarius and Bolter LLP, that they can look us up and contact us through the internet.
Okay, Mark, do you have any last minute questions?
Yeah, well, I have one that like a class action that actually kind of hit home for me. I'm a member of a timeshare, and that timeshare did a special assessment in addition to the rather expensive annual maintenance fees that you pay, like nearly $1,000 for most decent timeshares. And well, we got this bill in the mail for a special assessment for $2,000, which we didn't pay, and apparently a lot of others didn't pay either. And a group apparently got together, and they were able to put a class, obviously large enough, but not a big class, certainly not involving thousands or millions of people. But they successfully sued in California this vacation club. And it was determined that those special assessments were not legal. So that was there was an example of a relatively small group of people getting together and successfully suing in a class.
Well, and actually in that case, rather than the typical situation where you're the plaintiffs trying to extract money, you guys were the defendants
Yeah.
trying to not pay.
Well, if they were sued, they were defendants. They may have filed what we call a declaratory relief
Okay,
action.
you're getting
Right.
a little bit too
Okay.
particular here. I'm a layman, remember, I get to use these terms, but okay, we are going to cut to our second commercial break, and here is the trivia question, which I know Mark's going to answer because he loves Seinfeld. And remember, the theme is death on TV shows. In Seinfeld, how did George's fiancée, Susan, die? Mark's smiling already. The first 3 callers with the correct answer. We always have to have interesting deaths here too. The first 3 callers with the correct answer win a free 3-day, 2-night stay at the Lighthouse Resort. Their website is lighthouse4fun.com. Call 888-912-1190. That's 888-912-1190 to answer this question. On Seinfeld, how did George's fiancee Susan die? Call 888-912-1190. Mark, you didn't need to write it down. I know you know this off the top of your head. Make sure to include your name, address, email address, spell it slowly and spell it out, please. Or say it slowly and spell it out. And phone number, and we will be right back. You both know the answer to that
Yeah,
one,
I
right?
know the answer to that one.
Oh, yeah. We TiVos.
A
Jerry was
word to
supposed
the
to get married
blind.
at the same time, and he reneged.
Yes, exactly.
We had a pact.
Was that the same episode as the puffy shirt?
But you know, it's hard to remember which ones go with
You're right.
other ones.
I know,
Yeah,
the
the
puffy
puffy shirt.
shirt.
But I don't want to be a cowboy or pirate. Yeah, I like that. Go ahead and mention that. That's funny. Okay. What do you want to cover in 3? We're going into email time?
Yeah.
And then we'll get into your shtick, and then the last one we'll just kind of cover general what's going on.
Yep.
Okay. You guys ready?
Ready?
Okay. Welcome back to the Best of Investing. I'm Edward Brown, your host, along with Mark Honk of Pacific Private Money. And when we cut to the second commercial break, we asked this trivia question. And again, remember the theme is death on TV shows. On Seinfeld, how did George's fiancee Susan die? All right, guys, all 1, 2, 3.
Licking the envelopes.
Licking
Licking
Envelopes.
envelopes. And what episode did you also think that was on?
Well, I wondered if it was part of the puffy shirt
Well, I don't want to
episode.
be a cowboy. Or no, not a cowboy.
Pirate,
I don't
pirate.
pirate. I
Yeah,
don't want to
George
be a
wanted to
pirate.
pick out the cheap wedding invitations and I guess the cheap glue on the envelopes.
She licked
She was
poisonous envelopes.
Poison-
That's a tough one there.
poisonous glue on the envelopes.
Okay, Mark, we received an email for you, and the question is, if I invest with you, how long until my funds are invested? In other words, if this person gives you money, how long will it sit around not earning interest until you're ready to place it into one of your deeds of trust? And remind our
Oh,
listeners
sure.
what you do for a living.
Sure, good question. Well, I'm president of Pacific Private Money. We're based in Nevada. We're a private lender to real estate investors. We make real estate secured loans. Those are loans that are funded by private individuals, and those loans are made secured by real estate in the Bay Area. So we're a local private money lender. Our borrower clients are generally real estate investors, people out there buying bank-owned properties or maybe buying rental property. And our lenders are just private individuals looking for high yields, high secured yields on their savings. As we know, banks pay nearly nothing, and the stock market for a lot of people has had its wild swings up and down. Of course, we've all been witness to that over the last 10 years. But even more so, even if you have stock and equities and other investments, it's always a good idea to diversify. A strong proponent of diversification, and if you want to look at options for diversification, you really owe it to yourself to look at what's known in the industry as trust deed investing or trust deed secured notes. It's essentially where you, the investor, become actually the lender. You're the bank. So at Pacific Private Money, we promote our business to 2 different types of clients. We have our borrower clients, then we have our lender clients. And so our lender clients will use their savings or their IRA or their trust funds, and they will fund notes that we originate, underwrite, and document to real estate investors. We do the note and the deed of trust. Everything's handled by local title companies. Everything's insured and secured. So the question...
So I think that's the main thing that people have to understand is that their money is secured by the deed of trust.
It's a
got
financial
collateral.
instrument. I mean, we call it trust deed investing, but it's technically not investing. When you put funds in, when you loan your funds in this manner, it's a security instrument. It's a financial instrument. So you have all the rights and remedies as would Bank of America or Wells Fargo when they make a loan secured by a property. So in this case, the question is once an investor invests their money, when do they start earning? And
Yeah,
the good
right.
news about how we operate at Pacific Private Money, and I know many private lenders operate this way, is we do what's called individual trust deed secured notes. In other words, we don't have a mortgage pool. A mortgage pool is where you pool funds together of many individuals, and you have an interest in that fund, not in any individual piece of real estate. What we do by doing individual trust deeds is that we underwrite a loan secured by a specific property. The money is being lent to a specific borrower, and we distribute the opportunity. Once we underwrite the loan and we decide we like this loan, this is a loan that we would fund ourselves with our own money, so we're going to make this available to our stable of investors. So we prepare an executive summary, 1 page. We distribute that via email to our stable of investors, our growing stable of investors, I might add. It's, with the kind of rates that you get at the bank nowadays, a lot of people are seeking higher yields, so it's a great time to be looking at this type of investment.
What kind of yields are you giving clients right now?
8 to 10%, depending on.
That's amazing.
It is amazing, yeah. And in short-term notes, we're talking maybe 1, 2, 3 years at the most. So these are short-term investments.
Well, and the big thing I like about what you do compared to the mortgage pools is that the individuals actually get to see where their money is invested. Whereas when you're in a pool, you don't have any choice. It could be over here, it could be over there. And so it's a lot better.
Well,
to know
that's exactly
specifically.
right. And you also get to you decide the collateral. I mean, many of my investors, when they turn down a funding opportunity, they say to me, I wouldn't want to own that property. Because they're always looking ahead. They're going, well, if I
Smart.
make a
It's very smart.
loan to this person secured by this particular property in the Bay Area, if this lender defaults and I have to foreclose, would I want to own that property? And that's really the smart trust deed investment.